Dr. Sikkenga, welcome to Constituting America's Constitutional Chats. We're going to get started with your opening comments, but first I want to ask Aubrey if she'll bring up the 10th Amendment. And we thought we would read that aloud with our audience. It says, undelegated powers kept by the states and the people. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So Jeff, we're going to just ask you if you want to give us some opening comments on the 10th Amendment, and we'll go to questions.
Happy to do that, Kathy, and thank you all for having me on. Really appreciate, great to be back with you. It's been wonderful to celebrate the Bill of Rights Day, and I love this build up to it. Look, walking through each of the amendments, it's so important for us to understand what they mean and to have a great conversation about their importance even for today. So I'm just glad to be with you and to share in this. Two words that stuck out to me when you read that 10th Amendment are delegated and reserved. And those, I think we should focus some attention on and think about that and what they mean, because I really think the 10th Amendment, as you know, like all of the first 10 amendments of the Bill of Rights, they don't create rights. They don't create anything new. They just codify the understanding of the founders and the founding generation about the rights the people had and about the system of government that they were enacting, right? If we remember the history of this, the Bill of Rights is in large part a response to people called the Antifederalists, who opposed the creation of the Constitution and in part were worried about the lack of a Bill of Rights, which had been very typical in state constitutions that had been created during the time of the American Revolution. And here comes this federal constitution from Philadelphia without one of those. They were very used to that, and they said, hey, what's going on? So some of them objected and even left the Constitutional Convention, like George Mason, and some saw it from the states and weren't sure they liked what they saw. Thomas Jefferson saw it from France, where he was as U.S. ambassador, and he wasn't sure he liked what he saw. So there were a lot of people, important people in America, influential, who said, we need to have a Bill of Rights to guarantee, not to give us those rights, but to guarantee those rights and powers that we already have. And I think the 10th Amendment needs, like the other first 9, needs to be read in light of that idea, that it's not creating anything, it's codifying in writing down on a piece of paper in law the principles that on which our government are organized. And the first principle there is delegated. It's really important to understand when we think about the 10th Amendment that the federal government only has the powers that are given to it by the Constitution, right? Which means a very simple question when the Congress or the president is ever considering passing a law or carrying out an action. The first question is not, is it a good idea? Do I like this? Is it right? Should we do this? The first question is it constitutional? Because if it's not constitutional, it doesn't matter if it's a good idea, it can't be done. So that's the idea of delegation. The federal government gets its powers from the Constitution, and the Constitution gets its powers, as the preamble says, from we the people of the United States. But we the people don't give all the power of government to the federal government. A lot of it remains with the states. And that's the idea of the second word, reserved. The reserved powers of the states. The states had lots of powers under the Articles of Confederation, which came before the Constitution, of course, and they maintained a lot of those powers, in fact. So in defending this part of the Constitution, this idea of delegated powers, if I could take a moment to just read from James Madison. I think he's always pretty good to cite when you're talking about the Constitution. This is from Federalist No. 45. This is defending the Constitution. And the charge he's defending it against is people say the federal government will have too much power. This Constitution will give it too much power and it will destroy the states. And here's what Madison says. This is in the middle of Federalist No. 45. He says, the powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former, meaning the powers of the federal government, will be exercised principally on external objects, as war, peace, negotiation, and foreign commerce, with which last the power of taxation will for the most part be connected. The powers reserved to the several states will extend to all the objects, which in the ordinary course of affairs concern the lives, liberties, and properties of the people and the internal order, improvement, and prosperity of the state. Right? The basic point there is the federal government is given powers by the Constitution, but those are enumerated powers. They're listed, they're laid out, and what powers it does not have, it's not given, it doesn't have. And that's who has them? The states keep those powers. The people keep those powers. And that's exactly what the 10th Amendment says. So it really, as I said, is just a codification, a writing down in law of the principle that was always guiding the founders as they created the Constitution. And it was written down to make sure that the people understood this, the Antifederalists who were scared of the Constitution understood this, and the people running the states and the federal government knew this, that they would have to respect that idea that the states have reserve powers. And as Federalist 45 said, they have a lot of them. They're the ones who are supposed to be doing most of the legislation in the country on all of those important issues. That's the founding idea of it. And we see over the course of American history, lots of controversies involving the relative power of the federal government and the states. We sometimes call that federalism, and that balance of power between them. We see it early in cases, and the Supreme Court starts taking up cases. And we can certainly talk a lot more about Supreme Court decisions on those kinds of issues. Starting way back, the main bone of contention starting back early in the 19th century and continuing really through the 20th century between the states and the federal government has been the commerce power, the power of Congress to regulate interstate commerce, and how far can it go in taking over what had been state powers, because that is the one new power that the Constitution is given as opposed to the Articles of Confederation. Before the Constitution, the national government under the Articles didn't have the power to regulate interstate commerce. After that, they do. And that's a big change. Madison says that there in Federalist 45. How far does it go? Well, as the economy has gotten more national, that power has gone further. And there have been a number of court cases in which the 10th Amendment was brought up to say, is the 10th Amendment a check on the federal government's power, especially its commerce power? One case that your listeners might be interested in is a case called Hammer versus Dagenhart, which was taken up in 1918, where the Supreme Court said, no, the 10th Amendment limits the commerce power of Congress. It can't invade the powers of the states when it makes regulations. But then in 1941, as the Supreme Court sometimes does, only 23 years later, it changed its mind and said in a case called United States v. Darby, no, the 10th Amendment doesn't limit the commerce power of the federal government. And that allowed for much broader federal regulation under things like FDR's New Deal of the economy and limited to some degree the power of the states. And what's really interesting is that was the understanding of the 10th Amendment all the way up to about the 1980s and 1990s. And then the Supreme Court really got back into the picture again and started saying, no, some of these federal regulations are going too far. They're infringing on the powers of the states. And when they didn't uphold it, the political process did. I'll just give you one example. Some of your listeners may not remember this, but there used to be a national 55-mile-an-hour speed limit. And that was the federal government got the states to do that, change their speed limits back in the 1970s and 80s by saying, if you want our federal highway money, you have to change the speed limit on your highways. And so Montana had 55, Rhode Island had 55, my state of Ohio had 55, everywhere across the country. There's even a protest song, a rock and roll protest song called I Can't Drive 55. So it was a real live political issue. Eventually it got overturned because people said the speed limit should be a matter for the states to decide. That should be that's a reserve power of the states under the 10th Amendment. It should be a power that the states have to set their own speed limit. And of course, that sounds like a small thing, but it affects how we travel every single day on roads. So I would say that the 10th Amendment has made something of a comeback. since the 1970s. And today it's considered a very important part of our Constitution by the Supreme Court. There's a balance, I think, right now between the federal government power and the state government power on the 10th Amendment, but certainly it has been revived starting in the 1980s. And I think people have realized, both on all sides of the political spectrum, that it's a very good thing that states can make legislation and be different from one another. They can differ on speed limits. They can differ on all kinds of different regulations and areas of life, because all our states are different from each other. They're different and distinct political societies, and they ought to be able to govern themselves consistent with our great union of states. That was the idea of the founders, and I think we're seeing a movement, I'm glad to see it, back toward that idea today.
Well, that's great. That's a really wonderful overview, and appreciate that very much. I had forgotten about that song about driving 55. But I do remember that. Janine, would you like to come in with any questions, or do you want me to go straight to Tova?
Well, I just have a couple that you were, is that okay?
Sure.
Just go ahead and start. Okay. That was very thorough. I was waiting to hear, I always love to hear modern day examples, and you did throw some of those in, which I would love to hear a couple more, because as I really feel that our founding fathers would be a little bit disappointed by the enormity of the federal government, and that the states, that this is really intended to protect states a lot more than they have been protected over the years and years and years. It was interesting to hear the dichotomy of what was overturned in 41, but as opposed to the earlier Supreme Court decision. One of my first questions is, I was comparing the 9th and 10th Amendment, and we know that the Bill of Rights is something that the Antifederalists wanted, because they felt like they weren't getting the protections of their rights that they needed. But if you look at the 9th, it's really interesting to me. The enumeration of in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And I wanted to compare the 9th with the 10th, because the 10th also mentions the people and what that difference is. But before I get there, it seems to me like the 9th Amendment was to appease those who wanted a Bill of Rights, because it's saying, even though we didn't mention freedom of speech and we didn't mention this, we're giving it back to you here, that, we didn't mention that the government in the Constitution could take it from you. So thus, in the 9th Amendment, this is your Bill of Rights. It seems to me like that's what they were trying to do in the 9th Amendment, just briefly, because I know we talked about that last week.
Yeah, no, that's a very important point, Janine. The 9th Amendment and the 10th Amendment definitely are connected, and they're based on the same kind of political principles. The 9th Amendment, there were people, this might be surprising to us today, but people at the time of the American founding, including Alexander Hamilton, who wrote in the Federalist Papers, we don't need a Bill of Rights, because he said a Bill of Rights, he said, is unnecessary and dangerous. Interestingly enough, because he said it's unnecessary because we don't need to put in the Constitution that the government can't violate your freedom of speech, because we never gave it a power to do so. It doesn't have the power, so it's unnecessary to say it. And then what Hamilton says is, it's dangerous if you say Congress shall make no law abridging freedom of speech, because it implies that the only rights you have are the ones written down. And there might be many more rights that people have, like the right to associate and have their own friends and choose their own friends. That's not in the Constitution, but people do have that right. So I think that's actually one of the reasons behind the 9th Amendment, where it says, look, just because we didn't write this right down in the first 8 amendments doesn't mean you don't have it. You still do have it. And it's really a response by someone like James Madison to the argument that Alexander Hamilton made in the Federalist Papers. And I think the 10th Amendment is similarly along those lines. It talks about the powers of the states and the people, not the rights of the people. But those powers were never given to the federal government, just like those rights were never given to the federal government. The people retained them, and those powers were not given. And this is a way to just say, look, the political theory, the political principles of the Constitution is the federal government's powers are limited to what's put down in the Constitution. Everything else remains with the states and the people.
Yeah, I think I got that a little backwards. If that didn't sound, I think in my mind, I was thinking that this was in the Constitution and not in the Bill of Rights. I think I just got that all wrong. But anyway, you understood where I was going, because this actually is in the Bill of Rights. But it seems to me like it's an accumulation of the earlier, I don't know, whatever. It's a little confusing what my thought process was doing there. And I'm not sure I was actually correct, but I think you got it, what I was trying to say. What's the difference between the people, retained by the people, and in 10, when it also mentions the people? So it mentions the people in both 9 and 10.
So the Ninth Amendment says there are rights retained by the people. The 10th Amendment says there are powers retained by the people.
I think you said that. Right.
Right.
Okay.
So the right to one of,
Powers,
what would one of those rights
cool.
be? One of those rights retained by the people, the Supreme Court has even held the right to travel. That's not listed in the Constitution. But I think we would all agree that if you want to take a trip down to Florida or out to California or wherever, you have that right to go across the country. That's not listed there, but the Ninth Amendment makes it clear. And the Supreme Court has occasionally used the Ninth Amendment to actually decide cases. That's a right retained by the people. Just like it's used the 10th Amendment to say, wait, that power that Congress is trying to exercise, that's actually a power that the states have under the 10th Amendment.
What about the power? What would be an example of the power of the people in the 10th Amendment?
The power to organize their own state governments according to how they think best. Every state has a constitution, for example, and the power of the people of the various states to have their constitutions. In Ohio, we have a really different constitution than California or than New Jersey. And every state's constitutions are different, and that's a power reserved to the people of the states.
Really good answer. That was really good. Okay, I'm going to pass it on. And I love to hear these modern examples. The more the merrier. I think it's great for the students listening, because sometimes when we talk all these things that are nebulous, it's confusing, but you've done a great job with getting specifics. And I think more of that will be great as we move along here. So thank you so much.
Well, great. Yeah, thank you. That was an amazing overview. I was just curious about zooming in a little bit more on the language. The end of the amendment says, well, the powers not delegated to the U.S. by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And I was curious about that, or to the people phrasing. What does that refer to? And how do we know which rights are reserved to the states versus to the people?
Yeah, that's a good question. I mean, first of all, it's been a dispute for a long time, almost from the founding. There have been questions, is this a power that the federal government has, or is this a power that the state government has? And actually, to take an example, the power to regulate commerce. So can a state say, we don't want fireworks coming into our state to be sold in our state? Can a state say that? Or is that because it's coming from one state to another, is that supposed to be only Congress that could decide if you can transport fireworks across state lines? Because when I was a kid, I was from Michigan, and we always liked to head south to go toward Kentucky, and especially Tennessee, because fireworks were legal in Tennessee. And so we always liked to buy them in Tennessee and then bring them back to Michigan. All right. Well, who's supposed to regulate that? The state of Tennessee, the state of Michigan, or is it supposed to be Congress? Right. The Supreme Court has held, in response to your question, that there are 3 kinds of powers under the 10th Amendment and the federal government's powers. One, they call it exclusive powers, which means these are powers that are only held by the federal government. What would an example of that be? Declaring war. That's a power that only the federal government has. Conducting diplomacy. We can't have states sending ambassadors over to France to decide stuff. That's a power that only the federal government has. Then they say that there are some powers that both of them have, but the federal government's powers trump the state's powers if they collide. That's the commerce power. So, for example, if a state says you can't import fireworks, but the federal government passes a law saying you can bring fireworks anywhere you want across state lines, the federal law would trump the state law. And then there's another power called concurrent powers, which is the example that we always give is taxing. States have a sales tax. So every time you go to the store and you buy something, you pay a sales tax. The federal government could also impose a sales tax. States tax your gasoline, as everybody knows who goes to the pump. The federal government also taxes your gasoline. Though they have concurrent powers, they can operate at the same place at the same time. So there's those three different kinds of powers. And some of those powers, like establishing your own constitution for your state and organizing your state, that's an exclusive power reserved to the people of the states.
Well, great. Thank you. That was super thorough. And then I was curious, just a more broader question of why the founding fathers did place so much importance on the states. Because obviously, you know, that was how society was organized at the time. State identity was like a very large thing. And I was curious, was that standard in other countries? Like in England, was like the region you were from very important, or was it sort of just idiosyncratic to how America was founded, where you had like states not all being founded at once, but like founded by different, you know, organizations?
Yeah, I mean, it's definitely part of it that we started out as local communities, right? And then those communities became states or colonies, and then those colonies became a country. So it's definitely, you're right, it's definitely the way that we started. But I also think the founders, if you read the Federalist Papers or you read James Madison, they also thought it wasn't just, well, this is the way we have been, so let's just keep doing it this way. They thought, no, there's some really great advantages to having strong states and strong state governments. So states have been called laboratories of democracy, right? You can try things in a state. Let's try 70 miles an hour. Let's try 55 miles an hour. Let's have different hunting laws. Let's have different fireworks laws. We can try those and see if they work or don't work. And then other states can adopt those ideas if they work. Whereas if it was one legislation for the whole country, of course, then if it didn't work, it would be very bad for the whole country. So I think there's some recognition of the importance of states as laboratories of democracy. The idea that the closer the government is to the people, the more likely it is going to understand the needs and interests of the people, so that your local government understands what kind of park the local community should have. It's hard for the federal government to say that, but a local government can know that. How should your state fair be organized? That's a thing for a state government because they understand that Montana is different from Ohio. So I think there's a lot of good reasons why you would want to have that kind of variety among the states. And there is really enormous variety among the states that really reflects the culture of the states, the different interests of the states, and the different traditions of the states.
Yeah, definitely. And then I was just another more broad question. I guess as the country becomes more and more interconnected, you know, we have now, before it would take days to communicate from one end of the country to the other, now we can do it instantaneously. And, you know, the economies and have become more interconnected, and it's become a lot easier for people to move from one state to another, as well as now we have an understanding of things like, you know, pandemics where like germs can easily travel across states. You know, what argument would you make, you know, to someone who might say that would make the idea of having state sovereignty and states' rights less relevant? What would you say to that as to why they are still relevant?
Well, it's a great look. I think the pandemic is a really good example, right? On the one hand, you have disease transmission across state lines, so there's clearly a role for the federal government. But on the other hand, the pandemic hit different places in different states very differently. New York City was affected a lot differently from South Dakota. And it's really good, actually. I thought the pandemic was a great example of the importance of the 10th Amendment. Different localities and states could respond to the pandemic differently. So there has to be coordination, of course, because it cuts across state lines, but the effect and impact it was having in different areas was really different. And a one-size-fits-all policy across the country, that what would work for New York City pandemic regulations would definitely not work in South Dakota. So I think it's right. As the economy has gone national and commerce has conducted across, and you can go online and click a couple of buttons and get something sent to you from wherever in the next 2 days, definitely the federal government's power has grown as the economy has nationalized. That's true. But on the other hand, I think the pandemic shows there's really important role for the states still in being able to adapt public policy to the solutions that their people the problems that their people actually face.
Well, thank you so much. I think I'll now pass on to Jewel and Jordan, but I appreciate your time on the show today.
All right, we've had a lot of cool questions so far. I'm interested in this concept again of the Alexander Hamilton's critique of needing a Bill of Rights. There's something implicit in that critique which is a theory of government as a whole. So he's saying that the Constitution only gives certain powers to the federal government, and that the federal government wouldn't be able to infringe on these rights because it didn't have the powers to. I think that what is almost implicit in that is that we believe in a constitutional republic where you give certain powers to the government, and they can only do that regardless of even the expediency of a situation, or if we could find, if there was something efficacious, possibly if you could prove that it was efficacious, but they didn't have the power to do that, the government still didn't have the power to do that. I don't know if in our education of government that is really explored enough or really defined for people who are approaching the Constitution, of understanding that, well, our founders believe that maybe the government could do this and it could be effective doing it, but in the long run, there's almost many of them would claim it was a moral, that there was a moral reason to not give them the power to do that.
That's a
Could you
really good
comment
point.
on that?
Yeah, that's a really good point. I think it's an incredibly important point. And in fact, it was the idea that maybe we needed to write these things down in order to keep educating the people about their rights. That what you're saying is exactly right. Hamilton's idea, his theory is, well, it rests on the idea that the people will keep remembering that they have freedom of speech, or that they have freedom of religion, or that all the various rights that are in the first 8 amendments. It assumes that public officials will remember that in the federal government, and it assumes that the people will remember that and keep enforcing it. And what Madison came to, he wasn't thrilled by the idea of a Bill of Rights. He actually wrote a letter to Thomas Jefferson where he said, I support it. I don't think it's necessary, but I think it probably is a good idea. And what persuaded James Madison was the idea that the Bill of Rights could educate people, that it could educate public officials. Hey, you can't violate people's freedom of speech. And it would educate the people themselves. You have freedom of speech. Your neighbor has freedom of speech. And even if you don't like what they say, you have to respect their freedom of speech. So he thought it could help keep in people's minds this basic theory of government that you're talking about, which is government only has the power that it's given. The people have all of the rest of that power, plus the rights that they've always had. So the Bill of Rights ended up, including the 10th Amendment, having a kind of an educative role in helping keep alive these founding principles. And I really think it has that effect. If you just ask anybody, name me a part of the Constitution, I'll bet 8 out of 10 people will give you something from the Bill of Rights, not from the Constitution proper itself.
That's a pretty amazing answer. I had no idea that. I never thought about it as being educating, and it really is. And its ability to quote quickly, it's almost like the 10 Commandments in a way, of being able to adhere to them, and we do treat the freedom of speech and these things that the American citizen is able to say those before they're able to say other things from our governmental structure. Could you just say one more thing though on that? I think it would surprise a lot of people to hear that our founders believe that even if the government could effectively do something, we would not let them do it. We would say that they don't have the power to do that.
Right.
And that they,
yeah, it's a foundational principle of our Constitution. James Madison says it in Federalist 45. He says, look, the federal government only has limited powers. So just take speed limits, for example. If people in the 1970s thought it was a good idea to have a national 55-mile-an-hour speed limit to save oil, save gas, might be a good idea. The question is whether it was constitutional. And if you think, well, it's a good idea, it should be implemented, it doesn't mean it can't be implemented. As Madison says, it should be implemented at the state level then, and let the states take care of it. It doesn't mean it can't be done. It should be the states who do it. And the fact is today, I think we really forget when we say the government, we kind of are thinking about the federal government. But the fact of the matter is state and local governments do way more governing than the federal government, even still. Think about criminal law. all the criminal law shows that you see on TV or in the movies, sometimes it's the FBI. A lot of the times it's local police and state police and sheriffs, because they're the ones who actually do the vast majority of criminal law. Health and safety codes. When you go to a restaurant and you have to comply with all those that's almost all state and local, not federal. Those things regulate how you live your life every single day. The speed limits that you drive by when you're going to school or to this grocery store, that's all state and local. That's not federal. So I sometimes think we forget how important states and localities are in governing us, including our local community schools.
And it's also amazing just to think about how much, like, you're listing these powers that local governments have, and that fall under local municipalities, and that our founders also believed in these a bunch of tiny republics forming the big republic. And we've talked about that before here, but it's another one of those ideas that once you hear it, it's like, it's like a big denouement moment of so much more. You understand so much more. So getting back to this 10th Amendment, and like you said, the 9th and 10th are a little bit like this. In this 10th Amendment, you discussed it at one point in 1941. The Supreme Court actually ruled that a portion of the Commerce Clause was able to nearly supersede what this language is in the 10th Amendment, or seen as that the Commerce Clause gives the government the ability to do something which someone could make a strong argument does violate the 10th Amendment. Do you think that the founders, with this, with the inclusion of the Bill of Rights, and with it being a hot button issue that was debated, some did not want it, some wanted it, and it was important in order to get everybody on board to ratify it, that they would have thought that any portion of the Constitution that was seen in conflict with one of these 10 rights, that it would err on the side of giving the power of the government as listed in the Constitution, particularly if the area in the Constitution is more so of needs to be interpreted very where there could be many different legal theories on how to interpret it, but to use an interpretation in the Constitution to infringe upon or subordinate one of the 10 Bill of Rights?
Yeah, that's a really good question. In that 1941 case, the Supreme Court said, well, the issue was, do you interpret Congress's commerce power through the lens of the 10th Amendment, or do you interpret the 10th Amendment through the lens of Congress's commerce power? Which do you do? Which is the right way to look at it? Prior to that case, the Supreme Court had said you look at Congress's power through the 10th Amendment. In 1941, they switched it and said you look at the 10th Amendment through Congress's commerce power. You start from the powers of the federal government, and what's left is what the states have. Before that, it was start from the powers of the states and then figure out, if you're in one of these questionable areas, what powers are left to the federal government. That was a big switch, was a really important constitutional change. I'm quite sure that founding fathers like Thomas Jefferson and James Madison would not have agreed with that. They would have said, you got to look at both the 10th Amendment and Congress's powers through the lens of the principles of government that you were talking about. And that's how Madison talks about in the Federalist Papers. Jefferson definitely believed that. Maybe there'd be some disagreement with a person like Alexander Hamilton. The founders could agree on big principles and not agree on every single issue. But I think in general, they would have said there's a big role for the states, and when in doubt, you should probably err on the side of the states, because the danger of one uniform federal policy for the whole country that ends up going wrong is such a big danger that we should avoid it.
Do you think that any violation that we've seen that we would think as being constitutionally minded, that we would say, okay, we think the federal government has overstepped this in the 10th Amendment, do you think that the fault would lie on primarily this shift, that the fault lies on the Supreme Court and the federal government, or do you think it falls on the states not protecting the people's rights and citizens' rights, and trying to rely on citizens as people going all the way up to the federal government?
That's a great question. Honestly, I think there's blame to go all around. I really do. I think some states have been very good in being assertive about their reserve powers. So some states even have offices of the 10th Amendment, so that they can understand their reserve powers. So some states have done a good job. Some states have not done such a good job. Some states have been resistant to when the federal government tries to attach money. Usually the federal government gets what it wants in a constitutionally gray area by bribing the states with money. I'll say bribing, incentivizing, as they say, the states with money. Some states are pretty good at saying, no, we won't do that. I would say the Supreme Court lately has gotten better in saying, and this, by the way, cuts across the political spectrum on the Supreme Court, of saying, hey, wait a minute, at a certain point, when the federal government, it passes incentive to extortion. And when it passes that line of attaching money and almost forcing a state to do something, then it's violated the 10th Amendment. And we have some recent cases on that in areas like education, where they say the federal government's gone too far. So I would say the Supreme Court has kind of revived this idea of the 10th Amendment and using it to judge cases. And some states have done it. I do think there's lots of room for the American people to relearn these principles. I think we're too often taught the government means the federal government only. We don't really think about the importance of our states and counties and local governments. And it is, after all, that's where we do our living. You know, if you think about how much time you spend of the day actually living, you live in a place, in a locality. And that local government and county government is really important for how you actually live your life. We ought to be paying more attention to that and be more insistent on the importance of local solutions to problems.
Just what you said about the federal government imposing stipulations on education. Do you think you could just do you have any particular examples of that? Because I think it's a very obviously important subject, and it almost seems that people get stuck at the parent-teacher association, the school board meeting, but don't quite realize that they can go to that next level of their state.
Where you mean
Of their state, and talking about the state ruling it, but that also comes then to a head when the federal government is imposing restrictions on education. So could you just talk about that for a minute?
Sure, I'd give an example, and this is not at all a partisan example, but No Child Left Behind law that was passed, had bipartisan support. It was passed under the George W. Bush presidency. I think it used a lot of incentives, bribe maybe. It used federal money to get local school districts, states and local school districts to start doing stuff they might not otherwise have chosen to do in educating their students, focusing on certain areas, for example. Why? Because the federal government said, if you want our money, you have to test students in these areas. And it was a top-down solution to problems in education. And it turned out, of course, and I think is widely believed now on all sides of the political spectrum, that was not probably a very good law. It was probably not wisely executed. And it really ended up putting teachers in a bind. It ended up putting students in a bind, school districts in a bind, and they ended up neglecting other parts of education, for example, like history and social studies and civics, because the federal government wasn't saying those things should be tested. And so I'd say that's an example that we are living with still today of a place where there should have been more respect for state and local control of education.
And that's when the states should have really fired back at the federal government and said, this is my 10th Amendment right. So
yeah. And they should have said, we won't take the money, but that takes a lot of courage.
Yeah, it's funny because I work in schools a lot, and you see that hyper focus on math, and you think you can do a lot with math, but unless you know your history, you're bound to repeat it. So it's really interesting because you can't put more focus on one subject. Yeah, we have them all for a reason, kind of. Man, you got me on a tangent. Forgot my
Well,
next
but I
one.
could just say one last thing about that. Look, math is really important, but when the federal government attaches those kind of strings and schools start hyper focusing on math to the exclusion of other subjects, I always say, look, math's important, but most people are not going to be mathematicians their whole life. But everybody's going to be a citizen their whole life. They have to learn the history of our country and our founding principles so that we can be a self-governing republic. That's so important. And if you have federal policy that is forcing states away from that, then it's not just a 10th Amendment problem. It's a problem for the whole country.
Yeah, for sure. This really seems like an amendment that without it our founders could not have agreed to pass the Constitution, because there's so much focus on states' rights. And, this is the one where they really find it. Unless I misspeak, this is really all you have to stick to in our amendments. So can you talk a little bit about who I know you said Jefferson was a big proponent, but were there any other front runners of the 10th Amendment that made it a necessity?
Well, there were people like George
Necessity.
Mason. Yeah, look, there were people like George Mason, but I actually think that James Madison himself was converted to this. And when he proposed the Bill of Rights and he made his speech in Congress introducing the Bill of Rights, I think he had come around to the idea that we need the whole Bill of Rights and we need the 10th Amendment. And later on, when he authors, some of your listeners might know the Virginia Resolution against the Alien and Sedition Acts, he talks about the importance of states being the ones who should be protecting the lives and liberties and properties of their citizens. And that's reserve power of the states, not the federal government intruding on freedom of speech. And he almost quotes himself from the Federalist Papers. So I think that a person like Madison, I don't want to say he was converted, but he was not as strong a believer in something like the 10th Amendment when he was at the Constitutional Convention. Over time, he came to see how important it really was.
Thank you. I think it's time we move on to some audience questions. I know we have them stacking up.
Yeah, and thank you so much, Jeff. This has been great. We want to take a minute and recognize some of our students who are on today. We have David Birchmeyer with 2 students, Francisca Amato with 3 students, Terry Zalesnak with 3 students, and then Samantha Rogowitz with 120 students at Washburn Rural High School in Kansas. So we're so glad that y'all are all with us today. And David Birchmere, one of our students, asks, what is your opinion on the Internet Bill of Rights? An example, censorship from social media. Who has the authority, states or federal?
Well, if it's a matter of interstate commerce and the regulation of interstate commerce, it would fall under the federal government power. But it doesn't mean that states can't do it. So if the federal government, the Supreme Court has held that if the federal government doesn't regulate a certain area of interstate commerce, and the internet is almost definitely interstate, right? It goes across state lines. If the federal government doesn't do it, a state can do it. So they could regulate the internet. For example, they could impose sales taxes on the internet, which they do. If you buy something on the internet, it says, what state are you in? And it will ask you and calculate your sales tax. The federal government could exercise its power, and if it did, it would displace it would displace those state regulations. But until the federal government acts, it's an area that the states can act in under their reserve powers articulated, preserved and protected in the 10th Amendment.
Interesting. And then Sandy Thatcher asks, how much power does the 10th give the people vis-a-vis the states? Does state sovereignty always trump individual citizens' rights, as it seems to be the case here in Texas when the state government overrides city ordinances?
Well, that's a really interesting question. That's really left to the states. So some states have the counties and are really powerful in certain states. They run the school system, for example. Here in Ohio, counties are very weak. The local communities run the schools, and we even have something called the home rule provision in our Constitution, which says that the state of Ohio can never abolish a town. It can't change it. It can't override it. So, but that's a matter, that's why I say you get variety when you have federalism. Different states have different arrangements. In some states, state governments are very powerful compared to local governments. In some places, the tradition is local is more powerful than state. And it really just depends on the state. A lot of it, frankly, comes out of New England. So if your state was settled by New Englanders, like Ohio was, you typically have very strong local governments. If your state was, the farther south and west you go, the stronger the states are and the weaker the local governments are. Typical, not always, but typical.
Now, and in keeping with that theme on the importance of states, Robert Spiegler asked, should we as citizens study state constitutions? And if so, are they available on the internet? And I went ahead and answered Robert partially with that in that Constituting America did a 90-day study a few years ago on the states, and we have an essay on every single state, and we touch on that state's history and on their constitution. So I answered in the Q&A with the link to that state study for any listeners that might be interested. But what else would you say on that, Jeff?
I'd say some state constitutions are really long reading. The state of Texas Constitution, the state of California Constitution, because they're very easily amended, right? At one election, a majority of the voters can amend the Constitution of California. So it has a lot of amendments, a lot of changes. Sometimes they're consistent with each other. Sometimes they're not always consistent. And it makes those state constitutions really long. So can you read them? Yes, absolutely. You can find them online. You can go to your state government website and find them, or you can just find them out there doing a search. They're definitely there. Some of them read a lot like the US Constitution, and some of the more modern ones sound very different from the US Constitution. They sound much more modern, and typically they're much longer than the US Constitution. Doesn't mean they're better, just means they're longer.
Well, thank you. And Brad Haston asks, why did Madison initially support the national veto over state laws? And then why did he drop his support for this? And I know we've talked a little bit about that, but would you like to say a little bit more?
That's a great question. Madison came to the Constitutional Convention convinced that one of the problems facing the United States was the state governments, that they had been partial, they had been narrow in their thinking, they had been unjust toward their own citizens, and they had been unjust toward the citizens of other states. So he under the Articles of Confederation, he actually wrote something called The Vices of the Political Systems of the United States, where he said this prior to the Constitutional Convention. So he went to the convention thinking, I think we want to secure a republic here. I think the threat to the republic right now is state governments that are out of control. But once and when he left the Federal Constitutional Convention, he was still disappointed he didn't get the national veto. That he hadn't changed his mind over the course of the convention, but he lost and he wasn't going to die on that hill, as they say. So he just gave up that fight and said, well, we'll do the best with what we can. Over time, he came to see that that was not the problem that he thought it was going to be, that the problem might be too strong of a federal government or an overbearing federal government. So I don't think he changed his mind. He still wanted to say, how do we maintain a healthy republic? But he changed his mind on what the danger to that was.
Okay. And Brad also asked, do you agree that the Federalist Papers supported the right of the federal government to step in to address issues that the states have failed to protect rights, such as civil rights, and the need to allow the federal government to create economic programs that could effectively address issues like the Great Depression?
Well, there is a big change. We didn't talk about this, but the 14th Amendment, which is passed after the Civil War in 1868, does change the balance between state and federal power. So, for example, it clearly gives Congress, it says no state shall, for example, deny equal protection of the laws to people within its jurisdiction. That had not existed before. So the federal Constitution was limiting what the state governments could do, and it gave Congress the power to remedy those violations. So it really did change a little bit, like federal civil rights could now be protected by the federal government. It wasn't just left to the states. So that's a big change. As far as economic programs go, the big debate at the time of the Great Depression, whether or not the New Deal was constitutional. I think we sometimes forget that, but there was a very lively debate. The Supreme Court, until about 1937, had held very narrowly that a lot of what FDR wanted was in fact unconstitutional, that it was invading the reserve powers of the states. And then the famous switch in time saves nine. and they changed their mind. And ever since then, it's basically been accepted, although there are some justices today that still think the Supreme Court was wrong in 1937 when it changed its mind.
Thank you. And then Ed Brookoff asks a pretty general question, but he writes, I believe that the entire bureaucracy, which has been created and growing in scope since the end of the 19th century, is unconstitutional. How do we return to a closer resemblance to the ideas of our founding fathers when Congress continues to enact laws which empower or create more of these departments, and the SCOTUS seems stuck in that 1913 mentality as well?
That's a great question. I think the ultimate responsibility rests on us as the people. We, the people, we have to insist that state governments be taken seriously. We have to call on our own state governments and local governments to take seriously their responsibilities. And we have to be vigilant about the Constitution. And when we vote, we have to vote and speak on constitutional ideas and constitutional principles. It's really a matter of re-educating ourselves and our children and grandchildren about these constitutional principles. That's the place ultimately where the people are the guardians of the republic ultimately. And if we want to change this, we need to restore power to the local and the states. That's a way to cut down that bureaucracy that he's talking about. But it really does start with us.
Well, exactly. And we just have a couple of minutes left. And one way that we can be better educated and informed citizens is to go to the Ashbrook new website, americanfounding.org. And Aubrey, could you bring that up real fast? We want to just make sure the listeners see it. We dropped it in the Q&A, and there's a lot of great resources here. And if you scroll down, it's divided into, scroll down. It's divided into the Case for Independence, Constitutional Convention, Debate and Ratification, and then Bill of Rights, what we're talking about today. And so if our listeners want to learn more about the Bill of Rights, we encourage y'all to check out Ashbrook Center's website, americanfounding.org. So, Jeff, thank you so much. This has been just a really enlightening program, and I think we've all learned so much. I want to turn it back over here to Janine in the 2 minutes that we have left, and see, Janine, if you want to make any closing comments or ask any more questions.
Well, I just want to say, Mr. Sikkenga, you were amazing. You were just simply terrific. What a great guest, and we hope that you'll come back again. Lightning response to all those questions. You had everything at your fingertips, and you gave wonderful modern examples. Very thorough, terrific. So thank you so much. And I would also like to give a shout out to all the fabulous, the panel, of course, everyone on the panel, but also those who joined us today. Thank you for joining us, and I'm thrilled to hear all the schools and all the students. So we look forward to seeing you next time. We have some really good ones coming up. I don't think I should say yet, but let me just put it this way. Kids are really going to like it. Students are really going to like it. All right. Thank you so much.
Thank you, Janine. And we are taking a break for Christmas, and we're going to be back on Tuesday, January 3rd, which happens to be the day that the new Congress is going to be sworn in. And we're going to be talking about the Congress in our first episode on the Congress and the Constitution. So we encourage y'all to go on our website now and sign up for Tuesday, January 3rd. So you don't forget, 2 p.m. Eastern, we're going to have a great guest. And we wish everyone to have a wonderful holiday season. So thank you very much.
Bye, everybody. Merry Christmas.
Bye.
Would Mr. Sikkenga like I keep getting it wrong. Sikkenga. Did I get it right that time?
You did. Thank you so much for having me. I really appreciate being with you again. It's great. I love the work of Constituting America. You guys are doing a great work for the country.
Well, so are you. We look forward to having you as a guest again if you'll honor us with that. So thank you so much.